Okay, welcome back. So, meanwhile, after we saw what happens or what's happening in Washington and what may be starting to happen to Chicago, meanwhile, back in Georgia, we've had our own drama today. Earlier today, there was a hearing, an emergency hearing at that. It was called by the Fulton County Court in order to potentially consider contempt proceedings against the Fulton County Commission for failing to comply with a previous court order. We're lucky enough to have Jason Frazier with us. We're going to bring him in now. Jason, how are you, my friend?
I'm good. How are you?
I am good. We're running solo today. Todd is still on his way back from Beirut, so it's the Jason and Bill show for the time being.
All right.
So you had quite an experience today. I don't want to steal any of your thunder. I'll just kind of set this up so people make sure they have a good ground setting on what happened. So there was a previous court order for the Fulton County Commission to, in fact, confirm you and Julie Adams as members of the Fulton County Board of Elections. You'd been nominated, almost a month ago? Is that right?
It's been a couple of months now. I think it was back in June. Yeah.
And unfortunately, the Fulton County Commission, as they did last time, has been resistant to specifically your nomination, but really both of them. So tell us about what happened today, and if you can, a bit of the order as it was issued, please.
Yeah, Bill, it was a packed house today, to say the least. I mean, it's gone from this is our third hearing. First hearing, there were, it was me and 5 friends and a couple other folks, and then that probably doubled on the second one, and today it was completely full. So a lot of folks there, a lot of reporters, a lot of folks on our side, and a few on their side. But essentially, what came down is the judge listened to arguments from both sides, and in my humble opinion, it seemed like the judge had heard their story enough times by now. I hear their attorney is a very good attorney at what he does, but I mean, you can only do so much with this case. I mean, the law says shall. Precedent is there. He even brought up the case from earlier this year where Julie Adams was required to certify an election, even though she didn't have full data to analyze that election and make sure that it was true and accurate as the law says. But the judge said she shall certify, and that shall requires her to certify, just like the shall in this particular case says they shall appoint said nominees. However, the Democrats sued Julie, but now the Democrats are saying shall. Well, maybe shall doesn't mean that this time. So it's, I've got to be careful what I say, because rumor has it there's probably going to be an appeal coming.
Understand. So if you can, let me go through a couple of my own observations, and then you can, if you hear something that I cover that you think is a bit different, then please offer that if you can. Sure. And I do want to make sure that you stay within the guidelines that have been recommended for you, knowing that this thing is still potentially live. So as the proceedings began, the plaintiff, in this case, the plaintiff is the Fulton County GOP, supported by a couple of attorneys. And specifically, they noted, the gentleman from on the plaintiff's side, noted that the court had previously ordered the Fulton County Commission to appoint you two. They noted, and you called it out a moment ago, the law that underscores this says once the nomination is produced by the executive officer of the Fulton County GOP, the county commission shall, and in this case, shall is taken to be synonymous with must, appoint their nominees. Well, the third point they came up with was, in addition, some of these folks have almost unbelievably gone on social media and said, even though I'm being ordered by the court to do this, I won't.
I wouldn't want to be their attorney. We'll put it that way.
Yes. And which is astounding to me because typically judges and courts are very unhappy. I'll use that word because we're on a family channel. To have anybody call their ruling, their decisions into question, and to literally publicly issue a video in which one or more, I think there were 3 members perhaps, that made very similar statements and simply said, I'm not going to do it. I don't care if the court ordered it or not. That seems remarkable to the nth degree to me. And the plaintiff's attorney did call that out. Now, the defense seemed to focus on several points, one of which being the commissioners really only have one tool to use in terms of what their work entails. They only have their vote. Okay, fine. They only have their vote. And so there's no other way that that is prescribed for them to make decisions. They also said, which seemed on its face to be surprising, they claimed, the defense counsel claimed, that the court cannot compel an individual to take specific action. Now, you mentioned a few minutes ago that a very similar circumstance came up with Julie Adams last year, in which she called out the fact that during certification of an election, some information, some data that she expected to receive was not made available. And she demanded that information be made available, if I'm stating this correctly. They neglected or refused or simply didn't. And so she said, well, I'm not going to certify. I can't certify realistically if I don't have the proper information. Same thing happened, or very similar thing. Fulton County Commission took the situation to court. And in fact, Ms. Adams was ordered by the court to certify the election. So it would seem that in that case, the court could compel individual action. But now folks on that side are claiming the court cannot compel individual action. Have I got those points pretty close?
Absolutely. It just seems very surprising that these board of commissioners would be as bold as they are. I mean, you mentioned a minute ago that 3 of the commissioners went on social media. Actually, 2 of them went on social media just this morning at 9 o'clock on the steps of the courthouse, and said how the court could not compel them to vote in a certain way. The other member, Marvin Arrington Jr., he was actually campaigning for donations to his campaign by stating that he wasn't going to vote to affirm Julie and I. So, I mean, that does not seem wise, in my opinion. Granted, I'm not an attorney, but I wouldn't want to represent somebody that is that boldly defying the judge's order. I mean, agree or disagree, I wouldn't think that is a wise way to go about it.
It doesn't. It certainly doesn't seem like it. So the hearing was at it began at 10 o'clock this morning, lasted a little over an hour. The judge made some final comments and then adjourned court. And then around 2 o'clock or so, the word began to spread that, in fact, an order had been brought down. And we found out within just a few minutes what that order entailed. So let's bring this up. And essentially, this is I suppose some people are saying that in positioning this is a win, and in some ways I think it is. In other ways, it does seem to leave some questions open. So I'll let you take, if you're able to, I'll let you take us through this. But essentially, the beginning is the judge did find for the plaintiffs overall in his ruling. And then he did certain actions. Do you want to take us through the actions, Jason?
Yeah, I mean, essentially, the judge delayed the fine until, I believe it's Friday. Correct me if I'm wrong. It's been a busy day. But
I think that's right.
My theory on that, and I haven't spoken to a lot of folks on this. Again, it's been a busy day. But I believe the board, if they chose to, could have put an emergency meeting together and given enough notice to have a hearing or a meeting on Friday. That's my guess. I'm not sure every organization has different timing on when how much notice they have to give before they could have a meeting. So I would speculate that the judge, they agreed that, hey, we could have a meeting by Friday. So that's the first opportunity that they could approve Julie and I. So we'll just have the fine start then. So that's kind of my guess on why he delayed it a couple of days.
I see.
But then, it's going to be $10,000 a day, and that is being paid by the board. So it's not on the individual members. And as a Fulton County taxpayer, I mean, let's be honest, I'm paying for it, and so is everybody else that lives in Fulton County. So it is a win. It definitely shows that there is a problem. It's bringing attention to the issue. As far as will they comply, I mean, your guess is as good as mine. I believe they are going to appeal, as their attorney alluded to. They are working on an appeal. So I'm not sure how that works as far as when they file the appeal. Can they delay this $10,000 a day fine? Does it accrue? There's still a lot of questions that I've got right now. But either way, a ruling saying there is a problem, and that's not a small amount. So hopefully that will compel them to do something. And if not, the folks in their districts may not be happy with that.
Yeah. So if we can, let me just enumerate the key points in the ruling. And he did say, I did not post the entire ruling because it's going to be too small for people to read, but he did have some choice words indicating that he was not pleased with the fact that the commission seemed to be making this a convoluted, situation and set of actions, or inactions in this case. And so he did impose a $10,000 per day fine to be paid daily by the Fulton County Commission, the board. And so that in and of itself has some challenges to it. Somebody's got to, I guess, be cutting checks and so forth each day to be compliant with this. And that is to continue until such time as the commission shall act to appoint the nominees of the Republican Party's executive officer as required by the local legislation creating the Fulton County BOE. And this, again, this fine is to be paid daily. So until they act, until they solve this problem and get you guys appointed, this ostensibly would continue. Second, the judge enumerated that he found them guilty of what's called civil contempt, but in fact had declined to find the defendants individually guilty of criminal contempt, and seemed to signify something about them not doing this directly in front of the court. I kind of question that, in that even with a traffic citation, if you don't show up to court and do what the court tells you to do, you'll find yourself facing a bench warrant in most cases. And these guys seem to have done much more, in my own opinion, than simply neglecting to follow up on a traffic ticket. To state they're not going to follow the directions of the court to a public audience seems to be
plenty of options, plenty of opportunities.
Seems to be much more aggressive to me, my opinion. And then lastly, the court did say that they would award attorney's fees to the plaintiffs, but would not determine the amount of those fees until further submissions or through stipulations made by the parties. And so that seemed to be we'll get to this, but we need more information once we understand what the attorney's fees actually are and what's being asked for.
Yeah, that last item is definitely a big win for us. I mean, the RNC is footing the bill for this, but still there's a limit to how many dollars there are. And if they can come out not burning a hole in their pocket and redeploy those assets to other lawsuits, that's a big win for us for sure. Yeah,
that's very interesting. I feel like I'd like to ask a question about the RNC's involvement in this. Would that be okay?
Sure, we can try it.
So how was it that the RNC became involved in this particular case? Did they come to you? Did you reach members of the RNC? How was it that they came together on this?
Yeah, from my standpoint, the Fulton County GOP reached out to our state chair, Josh McCoon, and then he reached out to the RNC. And part of the reason, in my opinion, that the RNC took this case Unlike they didn't take it 2 years ago when essentially the same thing happened. They denied me 2 years ago, and that's why Julie Adams is on the board.
Mm-hmm.
But they picked it up this time because they've been getting pressure from folks in other states that if Fulton County is allowed to continue to do this and not only pick the Democrat board members, but essentially they get to pick the Republican board members, then people are afraid that this could happen in their states. So it's starting to become a national issue very quickly. So RNC needed to step in, or somebody needed to step in to make sure that we start following the law here in Fulton County.
So the other thing, we haven't really addressed it in this discussion, but the other factor here too is different counties have subtly different laws, don't they?
They sure do.
And it's notable that in the past, I believe 2 years, maybe 3, two or three other counties have encountered issues with getting their county commission to, in fact, appoint the nominee made and brought forward by the local county GOP. In those cases, efforts have been made to correct whatever the issue was, but ultimately have not been successful in at least, I believe, 3 cases. So perhaps getting this issue highlighted and in front of proper authority might help solve this case for you and Julie Adams, but also perhaps prevent a similar occurrence in the future. Is that a fair statement?
That's exactly how I look at it. I mean, the judge even mentioned today that Fulton County is the only county he's aware of that has a law on the books the way they do. That essentially, it's worded a little different, but essentially the Democrats pick 2 members, the Republicans pick 2 members, and the chair is appointed by the Board of Commissioners. Every other county, there are several different methods in different counties, and in my opinion, it should be one standardized process statewide, or maybe in small counties, possibly you don't have 5 members because there are some really small counties out there. But essentially, it should be balanced and similarly handled statewide, in my opinion, as well as I'll be perfectly honest. I don't think, based on my experience, the Board of Commissioners should even have a vote. It should just be put through, and that would alleviate every bit of this.
Yep. So one of the things that some folks have brought forward is the fact that many elections, it's certainly federal elections, and of course elections for our state level officers such as governor, lieutenant governor, so forth, require the summation, the aggregation of voting all across the state. And so it would seem wise to have similar to, you could make the argument, identical requirements in all counties, especially in a state like Georgia, which has 159 counties. It would seem to create the potential for some level of chaos if you've got different rules in different counties. And so many are hoping that this and other instances like it could pave the way for a more consistent way of doing this that kind of assures you have a set of guidelines that can be complied with all across the state, and then you end up hopefully with a less chaotic result at the end of an election.
Yeah, that's exactly how I see it. I mean, you shouldn't have every county required to go through court to set precedent, to decide exactly what the interpretation is on their particular law. Make it standardized across the board. That way there's no question if you're qualified, if you're a registered elector in that county, put in a couple other qualifications in there that you're of age, that you can be registered to vote there. Maybe you've been a registrant for a year or something like that. Put some qualifications in there. But if you meet those qualifications and the party is fine with you being on that board, there shouldn't be political games that happen by somebody else, whether it be by the Board of Commissioners that might be, majority Republican in one county, majority Democrat in another county. Nobody should be able to play these games. It should be straightforward so we can get down to business.
That seems so reasonable to actually hear someone say that.
Reasonable. We're in Georgia.
Yep, you know it, brother. Okay. Any other points that you want to make? And I would like you to let folks know where to watch what you're bringing out, because you have a tendency to bring out very valuable information, whether it's on this instance with Fulton County or if it's got greater, more broad knowledge across what's going on with our elections or some other subject online. So offer what you can about what comes next, things that that folks need to keep their eyes on, and then how they can watch what you're bringing out, please.
Yeah, I mean, folks can follow me on X at Jason Frazier USA, and I regularly post things on there about issues in the voter rolls. Like there's somebody named unknown. There's several people with missing as their last name or first name. I mean, just a lot of kind of ridiculous errors, if you will, in the voter rolls that should not be there. So I like when the Secretary of State claims we have the cleanest voter rolls in the world, put some examples on there where things could be improved. So that's, and as far as the lawsuit, I will definitely be posting updates on that, as well as Fulton GOP and the state party there. There's a lot of folks posting, so just kind of follow us there, and I'm sure you'll be posting it as quick as things come out. So, we'll find out here in a couple of days if they decide they want to pay $10,000 a day, or if they want to follow the law. And if not, we'll be following the appeal process.
Well, that sounds great. And before I let you go, on behalf of, I know a lot of people in the audience are thinking, well, don't forget to say thank you for everything you've done, because you've been at this for 5 years or more now, right? And so an awful lot of work and an awful lot of sweat and toil to try to fix things in the state and also specifically in Fulton County. So on behalf of everybody, thank you for that work.
Thank you, Bill.
All right. We'll look forward to having you back soon, Jason. Thanks for being with us.